that, you know, we work with Real Estate and Bellox at this point. We will be, it may be necessary at some point in the future to commence litigation either to foreclose or to determine the reasonableness and the parties entitled to the proceeds from the sale of personal property. So I think that, you know, at this point it's informational. I guess I don't see that you need to make a recommendation to the council at this point, simply because it's not ripe for action.
Okay.
When does the repayment, when is it scheduled to start?
For this one, actually in July.
Any further comments or questions regarding this whole process, and or do you want to?
If you have any suggestions on, you know, me moving forward or, you know, dealing with people, and certainly this is an appropriate venue to voice those suggestions.
Scott, just because we, you know, people will see and hear about this one, there may be others that are contemplating actions. We did try to meet, had a meeting set up with this borrower, and that meeting was, my recollection is, was canceled, the initial one, and rescheduled for the day after this event was going to happen, essentially.
Yeah.
And you did have a meeting with her, or a conversation with her?
A few weeks earlier, I had a meeting. We talked about where she was sitting and some options for getting some assistance to examine the business and so forth. But since the action took place, then we had several conversations about where she felt she was, and my understanding was she was pursuing some kind of action with her attorney.
Okay.
And would we not encourage borrowers that might face similar issues to come forward prior to signing documents and getting things in a position that requires a lot of legal work and stepping and counteraction and action, I would assume we're going to see from this particular case, so that we could settle the issue, try to settle the issue, not that you always can, but see if there's a way to fix the thing before we get into all these legal ramifications. Or
yeah, I think that's good advice in general. I mean, and you'll hear it, you know, not just from attorneys, but from financial advisors, bankers, and the like. If you're having a problem, you need to talk to somebody. Ignoring it won't make the problem go away. You know, there may be assistance available, and in fact, that's been a large portion of what the legislature in our state and probably nationally or federally as well are trying to encourage with these new foreclosure laws. You've got to give them notice that there's help available, and you know, you've always had to, well, you haven't always, for the last 10 years at least, have had to give some sort of notice, but they've ramped up the amount of notices that you give in the bold-faced font saying there's help available and there's numbers to call. But starting with your lender is always a good first contact.
My question is, how do we get that information out to those? You know, meaning, how do we, other than, well, we can talk about it here, but how do we get it out to those who are received money in this process?
well, I think the local newspaper did a nice article on that there was a situation, maybe last week or the week before, and certainly interviewed the parties involved and tried to get the gist of what they could get as far as the facts out on the table. So I would assume we'll see a follow-up to that story, and as people will read and want to know, well, how was that handled and how was that done? And the awkward part is we really haven't, as Scott says, we haven't had anything happen to us.
Right.
So other than reacting to rumors, ads we see in the paper about selling things that we thought belonged to us, I mean, that's what we've just been reacting. And there's other parts to this story that are in the rumor mill stage, probably have validity, we don't know, and somebody's going to have to sort that out, whether or not that played any part in this. If a person was having trouble with a normal contract for deed, I'd go to Scott and say, Scott, you're behind, and how many days would you normally have to fix your problem?
Well, it all depends on who the vendor is. I mean, they may give you some workout time before starting a cancellation procedure. Cancellation procedure is a formal proceeding, much like a mortgage foreclosure. You serve a notice of cancellation of contract for deed, they have 60 days to cure the default. That's under current contract for deeds. Time frames vary depending on the date of the contract for deed, but for the last 20 years, it's been 60 days.
So in this case, that was canceled, that requirement of 60 days was canceled by her signing some agreement.
The quick claim deed, right, and that's another, you know, much like people give a deed in lieu of foreclosure, a person can give a quick claim deed, voluntarily terminating their interest in the contract.
And in so doing, if I just follow this through my own thinking, she created for a relationship between the city and her now, a situation where before she had declared her one loan of $68,415 where 10% would be repayable ultimately, where now it's all due.
Correct.
Yes. Recommendations, any other recommendations other than what you've heard from our council?
What would be the anticipated timeline if this thing kept progressing?
Well,
And she does go into default?
you know, we've got July, you said, repayment,
Yes.
first repayment is, so we have 2 months. We've got 2 months to be able to try and work something out with either with real estate or the Bellocks. And then as soon as the default occurs, I'm gonna say that 60 days, the amount of time between now and when default would occur is sufficient time to attempt to get this worked out between us and them, and at which point, you know, obviously we'll be coming back for more consultation and a recommendation or approval, or a recommendation for you guys to get to the council to approve any kind of settlement or agreements. But if it's not worked out in that 60 days, default occurs, and action can be commenced, you know, within 2 weeks of the default. And, you know, let me strike that. Although it's not required by statute, it's a preferred practice to give a 30-day notice of default and right to cure. Okay? It is required of certain banks for certain loans by Minnesota statute. I think it's a good practice to use. You know, and I don't know if that's a practice that you want me to use. It's not required in this law.